charged with criminal trespass. You're facing up to 6 months in jail. We're going to do probable cause again now that your lawyer's here. Okay, please.
On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, who both stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant, and the complainant and witness pointed to him, stating that it was indeed the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Is the witness.
So let me see, Your Honors.
I mean, he had authority to be there, and I know that you can revoke that, when you overstay your welcome.
Yes,
right?
Judge. So the complainant is the office manager and the witness is security guard.
Okay. Did you want to add anything?
Well, Judge, my issue is he's been at that facility for years, and he has 3 separate doctors within the same UT facility, and he was there for his doctor's appointment. And there's some contention as far as whether he was asked to leave or not, considering that doctor's appointments take months to schedule in advance, sometimes up to 6 months. So I don't believe that if he had a right to be able to see the doctor, I don't believe that a person that's unidentified, the original complainant, I think her name was Amy, should be able to come in to tell him to leave, if in fact she told him to leave. So I think there's...
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yes, Judge. And then he still refused to leave once security got involved. And we contacted the complainant as well, and to add...
You had spoken to the complainant?
Yes.
Oh, okay, tell me.
And the complainant said that the defendant was sitting in the lobby after his visit, and the reason he was asked to leave is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had concluded, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause to go forward now. Did you speak to them? Tell me.
They said he's no longer a patient.
No longer a patient. Okay. So you can't go back there. Okay, Mr. Proler, you must find a doctor, but it appears that they don't want you to go there anymore, at this particular doctor's office. Okay.
Well, Judge, my add, like I mentioned, he has 3 separate doctors within the same building. So is the court asking him to stay away from that particular single
correct
office?
Right.
Okay.
So if you have business in another part of the building, you can go. Just don't go back to this office, because chances are, if you go back there, they're probably going to call the police and they're going to charge you with another trespass. So don't go back over there, because they've warned you not to go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But okay, so then just stay away from wherever that office is, and you can use the other 2 places. But I'm not barring you from the building, just from going back to that particular office. What is the confusion?
Oh, I want to bring to your attention this alleged other incident.
Doesn't matter.
Yeah.
Okay.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
It's a UT Physicians Bel Air station, so I don't know how they organized that office there. So I think just one system. It's not necessarily separate offices, like different. Just be
if he has 2 other doctors that he sees there.
And that's part of the issue, because again, so it's part of the same system. So I don't know. They do have multiple doctors there, but it would be at the same facility. And they told us that he's no longer a patient at the facility. So presumably that means no doctors there, but we could clarify if you would like.
I think you need to.
Yes.
You definitely need to, because this could be a potential problem.
Yes, we can certainly
He's
clarify.
saying he's still seeing 2 other doctors
Yes,
there. They may not know of the other 2 doctors. You want to do that real quick to see, real quick? Can you give me 5-10 minutes? Let me see. So, hey, Alex,
Yes, sir.
also see, I mean, are there different, in most like buildings, there's suite 101, 102, 201, 202. How do they do it over there?
Yes,
Is it
Judge.
by like
We'll see how they organize.
the suite, and then
Yes, Judge.
is it possible that he can see the other two?
Yes,
And
Judge.
then, okay, yeah.
So, I was doing my due diligence on my end. And
Great.
I contacted, another provider in the facility. He is a current patient there at this time.
Right.
So I just wanted to verify on our side.
Alex, did you hear this?
Oh, I apologize.
So-
And Will, because this is your deal as well. So they've verified that council has verified that he's seeing another doctor at that facility.
Okay.
So what we'll do, like I said, you are on notice of what you can and can't do. We don't want you to go to the complaining witnesses in this over there, wherever they may be, wherever their office is. Do you understand? You can see your doctor if you have another doctor there, but I don't want you to have contact with these people here.
If I understand you correctly, Judge, I can continue doctor's appointments there, but don't.
How is the facility divided up?
This building is not the best building to have doctors in, to be perfectly honest with you. But you get off the elevators or stairwell, whatever route you choose, and it kind of wings off. Let's say.
Is there a possibility that you're going to run into these people?
The same floor, separate floors?
Yeah, I'm sorry, under what circumstances, Judge?
I don't want you to run into these people.
Is there a
And
way,
we say these people,
is there a way you can get to your other doctors without going to the cardiologist? In front of that building, in front of that suite?
I think I understand what you're saying.
Is there a different way you can go around?
I mean, it shouldn't be this difficult.
I know.
I don't understand why what is the doctor's name, or what is the facility? Who are we talking
So
about
we're
here?
talking about an Amy Whitetree. So she's the office manager for whatever department she's in.
I don't want you to have contact with these people.
Can I tell you something, Judge? I don't know. I mean, I now know who she is, but she did not identify herself at the date of the incident.
Okay.
And she didn't have a UT badge or anything. Some woman came and talked with me. Now I understand she has a name. I sure would like to hear the complaint has a name, if that's okay with you all.
I don't want any more issues. If they call me and they say that you're becoming a disturbance there, I'm going to revoke your bond and I'm going to put you in jail. Do you understand?
I don't blame you.
I don't want to make this any more difficult than it is. You know what you can, you know what you can't do. The condition of your bond is you're not to have any contact with the complaining witnesses in this case, not to go where they work. They don't want you to go where they work. That's it. If we get wind that there's any issues, only one thing's going to happen. You know what you can and can't do. I just don't know how else to explain it,
I
but
understand.
Sure, that's
Yeah.
pretty clear. And that'll be the only condition, Judge. This is his first contact with law enforcement. He's a retired captain of the Houston Fire Department for 22 years.
okay.
So he's not gonna be any trouble whatsoever. It's still misunderstanding.
Yeah, and if it gets to the point where you may need to find another doctor because it becomes impossible for you not to run into them, but you're the one that's on bond for this case, right? We'll give you as much as we can, but I just don't want any more problems. I don't want them to live in fear. I don't want them to live in, oh my God, is he going to come back? No, we've told you what the expectations are. That's it. Okay. If you have any questions, you've got a lawyer. He can help you out. If there are any issues that arise in the future, you can always come back here. We have an open door policy. So we're always here for you, whatever you may need. Don't take matters into your own hands and just be good. That's it. We'll have conditions for you to sign after you're done with that. Then you're on your way.
Thinking appearances are way for.
Correct.
Okay,
So
thank you.
because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court here, but you must stay in touch with counsel and he will tell you when you have to come back to court.
Sure, sure.
If he tells me that you've gone AWOL and he can't get a hold of you, you're not answering phone calls or text messages, that's when we revoke bonds. You pick up a new case, I'm going to revoke the bond. Okay? All right, guys. All right. So they're going to have it filed, let you sign it, and then you're on your way. Okay. Of course. Thanks.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrade? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
Yeah, she at home.
Did you come with mom today?
No, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bump. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're saying the bonds ultimate. dealt with those?
I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson then. All right, gentlemen, both of you have picked up criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer. It looks like both of you, Mr. Benson, are charged with theft, and you're facing up to 6 months in jail and or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. The agreement you have worked out, Mr. Benson, is 22 days in jail, credit for the 22 days so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you will be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, you are with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You can never take it off. And from now on, you're facing a minimum of 30 days in jail. Do you understand? Is this what both of you want to do?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. It will go on your record. It'll stay there forever. How do you plead to the offense, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it. Mr. Lowry, how do you plead to the offense? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, if any enhancements, just abandon it.
On the.
Oh, do we need to do it on the
Well, there's
theft?
one with the second conviction. on
Got it.
theft.
All right. So, Mr. Benson, you have a prior theft from 2019. Is this true?
Yes, sir.
Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a pack of gum, a big pack of candy, be careful. You could be facing some serious time next time. You understand? Okay. So, true to the friends. We'll abandon the other one. All right. Good luck, gentlemen. Thanks.
All right, gentlemen.
Oh, and Mr. Benson, your second case will be dismissed. I didn't realize you had it. Oh,
I was told I needed to approach on Mr. McCullum. He's not here today.
we have quite the, did you represent him before?
No.
Okay, we have quite the history with this gentleman
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think did it get dismissed or did he plead? I don't know.
One of them pled and the other one got dismissed.
So he's now picked up a new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten letters, or I'm sorry, emails stating that because of this case, I think he like broke his leg in half, is what he's saying. He broke his knee, his tibia, fibia. I don't know. He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be, but I was going to do probable cause number one to see, was there really an injury that occurred? I don't know.
It says he tripped and fell. The officer indicated that he tripped and fell as he was running.
Mind
Yes.
happen, please.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 Westridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant toss an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer wearing full uniform told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff, and the defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time. Is that what that says?
Doesn't say anything in the DIMS.
No, and it does not say anything regarding whether he was taken directly to JPC or whether he was taken to the hospital. This is a Houston Police Department case, so we do have the offense report, so I can.
Do you mind looking it up real quick?
Yeah.
Maybe just the DIMS doesn't say it. The emails that we've gotten is saying that he's in such pain and such dire circumstance that he cannot make it to court. But I have quite the history with this gentleman where
Yes, so he was taken to the hospital due to a leg injury. He was taken in an ambulance.
Does say that?
Yes, Judge.
So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it? When can we get him here? How? And we'll go from there.
I did see he has felony on the 30th, so I'll see if I can get in contact with him and find out if he's going to come to that, and if so, we'll just do it the same day.
Yeah, I'm okay with it.
Okay.
Okay, great.
Okay, perfect.
That way you can, now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So when you reach out to him,
Communicate
Don't-
or anything.
don't call me, don't email. It's been quite, just please.
Yes, sir.
Yeah, okay.
Are we given, because you said you wanted to think about the hospital. So you're saying he's 90 pounds,
Okay.
do you want Friday or?
I think that's it. I think we're done. What?
We have some plays that are falling around.
Oh, on,
Approbation and overstretch. I'm not sure. Garrett is one of them. I want to see this is Ray.
yeah, I remember. You said Garrett?
That, Iman.
I'm on.
And we have probation for Stovall.
I mean, unless,
Yeah.
all right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk, your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences.
Okay.
Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right?
I think there are many.
Okay. All right. All right. Hi, good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
How do you plead to the offense, sir? Guilty or not guilty? All right. I'll find you guilty, sentence you to good luck. Thank you so much, Ray. Hi.
Hi,
Good morning.
Happy New Year.
Happy New Year.
I am approaching this morning on Robert Moore.
More?
Yes, Moore.
More with an M. Okay. Oh, he's not.
Oh, no, that's somebody else. They both have the same last name. Yeah, I have another case that got moved to Friday. Her last name is Moore. No,
Is this is a new case?
Yes, it is.
16, Your Honor.
You mind bringing him up? Oh, this is the case. Okay. Okay. Right. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD, it's in my backpack. When you search, you're gonna find it, it's gonna be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it,
it was a flower, so.
it is a flower?
Mhm. So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may, so as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough, because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue. But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's going to happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's going to happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right. Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Judge, I have an Anisha White on the docket.
Okay, it's getting up there, but
Yes.
not up there.
So I just asked the state to eval the last time they did. I would like to get a trial date, but.
Of course you can.
Okay, then I'll do that.
Sure. Yeah, just talk to Ramona, whatever you want.
Cool. Thank you, Judge. And
of
then I
course.
also have a Coriel Dixon on the docket.
How's Miss Dixon doing?
She's doing well. Judge, she.
Did you finish it yet or what?
No, her last class was on 12/19. Then they took a break and they come back tomorrow. She brought her over the break homework and study guides that she's filled out.
Okay.
So she's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she takes the test, because she took the evaluation test already. Those results aren't back yet because that was right before the break. So we should know in the next couple of days, hopefully.
So let's set it off a week to see, and then we'll go from there. And then, but we can do just a longer date, huh?
Yep, sounds good. Thank you,
Okay,
Judge.
thanks, bud.
There was a video that's just found in this case.
I know, I saw it. That's why it's. So what, come on up.
Good morning, Judge.
Is he here? Is that him? That's not him, right?
No.
Okay.
My understanding is that he is still home with a sick child. I do have a doctor's note that I showed to the state. I don't know if that's sufficient for the court, but that's.
Okay. Yeah,
Is he wrong tomorrow or do you want to come on his regular?
Just regular.
Thank you, Judge. I do speak.
Yes, ma'am. You ready? Hey. Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
This is regular setting.
Okay,
We had accepted the plea offer and we're ready to move forward today before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will. to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first, and I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash, and one false move, they're going to file a motion to revoke. And if they prove it to me that you violated this probation, get ready. For you to complete it, well, what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess, they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first So it's a $3,000 fee, but let me ask you this, is this a 0.15 or above?
To Your Honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be a 0.15.
You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Ken. All right.
Judge, are you issuing a no driving license?
He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay, yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay, so if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So you can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000 plus the court cost, who's gonna pay all? Are you Miss Troyanne Marie Britton?
I am.
Miss Britton, you are charged, I'm sorry, you are wanted out of Georgia, Fulton County, Georgia specifically, for possession of a firearm or knife during a commission or of an attempt to commit. I don't know what, it just ends there.
Felonies, Judge Fleischer.
To commit certain felonies. Your lawyer has asked for me to set you a bond. I don't know. I don't know anything about you. I've never met you before. So I got to see who you are as to see whether I'm going to set you or not. You know, one of the main things is, are you a danger to our community? Number one. Number two, if we set you a bond, are you really going to go back or are you just going to take flight? Those are the things that we're really concerned with here. Amy, tell me about Miss Britton or Katie, or is it you or anyone?
Yes, Judge, I'm here.
Okay.
I would be a little bit concerned, Judge. I am seeing 2 failure to appears already on her criminal history. I see a possession of a pistol by a person under 18.
Wait, what was that?
A possession of a pistol by a person under 18. Interesting charge. And then I see a failure to appear. I see possession of a controlled substance, marijuana charge, willful obstruction of law enforcement officers, and aggravated assault, theft by receiving stolen property, driving without a valid license, another failure to appear.
Is that
so I am a
four
little
failure
bit
to appears?
concerned.
That's 4
There's-
failure?
No, I'm seeing 2 failure to appear, Judge.
Were they fugitive cases or just open cases elsewhere? And where is all that history from?
So I can't tell, Judge, if it's a fugitive case or not. I see that it's out of Fulton County. Let's see. I see Atlanta Police Department. It looks like most of these are out of Fulton County, Judge.
How long ago are the FTAs? Is it a recent or?
So one is from 2023. And the other one is from, trying to look for a date, Judge, is from 2024, from 6/28/2024, it appears.
And I'm assuming that 6/28 one is the one that's holding her right now.
It might be, technically the warrant that we have written down is possession of firearm. So I'm not, it doesn't specify whether it's a failure to appear warrant
You know
or
when the
not.
hold was placed?
Let's see.
She was booked on our.
It looks like it,
7th.
I'm sorry, it looks like it's from February of 24. Yeah, it doesn't, like I said, it does not specify that it's for the failure to appear.
Judge, so she hasn't been before your court. This is one of those cases where I'm not asking for a PR bond. I'm asking for a bond that would ensure that she turns herself into Fulton County. I've talked to her about your requirements if you were to set a bond, how that affects her, how that affects the bond. She needs to present herself. She's got criminal history, I'll give you that, but she hasn't been before your court before. We're asking for an opportunity for her to go turn herself in. She's willing to do that within 14 days and show proof of that. If she doesn't turn herself in, well, then I'm not gonna say, but at this point, it sounds like possession of firearms are most of the cases that she has.
All her cases are dangerous cases. Assault, ag assault, possession of a pistol. Now she's got a pistol case, committing certain felonies. We don't even know what the felonies are. Do you know?
No, Judge, not at this time.
I only heard of
A bunch of FTAs, at least 2 other FTAs. Now we've got a third. What? You really want me to set you a bond? I want hair. Not gonna happen. No, at some point, we got to say when. But, you know, you've racked up a bunch of criminal history. How old are you? How old is she?
She's, I think she just turned 19.
19 and all this?
Was that right about that, Troy?
Correct. I'm 19.
Absolutely not. I'm in shock that you're 19. And Katie, how many priors are we talking here? At least like 6, 7, 8?
It appears so, Judge, yes.
No, I'm sorry, but I just, you scared me, Miss Britton. Really, I don't think that I could trust you. I think if I set you a bond, it's something is going to happen, or you're just not going to go back. And I'm sorry, I can't.
Understood.
Right. The good news is that you've made bond on your other case here. So the time is ticking for Georgia to come get you.
She needs to waive today if she wants that to happen.
I'm sorry.
She will need to waive today.
So the process is that you can either waive or you can fight extradition, in which case they will get a governor's warrant, which will take up to 90 days. But if you waive extradition, that gives Georgia up to 14 days to come get you. And if they don't get you within that 14 days, then Harris County releases you. But at 19, with as many priors as you have, including 2 failure to appears, you really scare me. And I don't think that it would just, that it's time to pay. Just can't trust you, Ms. Britton. Sorry.
Would you consider any amount?
No, I mean, all that, and you're 19, it's hard enough being a person of color in today's society. And now with all these priors, all you're doing is you're digging yourself a grave. You're making yourself unemployable. You know, this life can be a great journey where you buy nice things, you take nice vacations, you get married, you have kids, and they come up to you, hey, I love you, mommy, I love you, daddy, you know? Or it can be a rotten, miserable of an existence where you're in and out of jail at 19. All these serious priors, come on. Stop. It's time to grow up. And me giving you a bond now would be just enabling you and telling you what you're doing is okay. It's not. And now we'll wait for Georgia to come get you. Thanks.
Thank you, Judge.
All right, you are Aguilar Barrera.
Yes.
Okay, sir, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant failed to maintain a single lane and run over a curb in an underpass in Harris County, Texas. Upon contact, the officer observed unsteadiness, slurred speech, bloodshot eyes, and a strong odor of an alcoholic beverage. The defendant did not consent to standard field sobriety tests. The DIC was read, and the defendant refused a blood and breath sample. A search warrant was signed and executed.
Can you see any prior DWIs? And have you see it?
I have no license on file, and there's no prior DWIs.
Okay. Mr. Aguilar Barrera, I don't know what your immigration status is, but if you were in this country without permission and you go to jail long enough and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. You do not have a Texas driver license. You are not allowed to drive. Do you understand?
Yes, sir.
I don't care what's going on in your life. I don't care if you need groceries. I don't care if there's a burning building and you have to save 50 kittens. You drive. I can have a contempt hearing. I can hold you in contempt, slap you with another 6 months in jail and or a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
Yes,
I am also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming any kind of alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you. You got out of jail quick because we gave you a PR bond. If you pick up a new case or violate conditions, I will revoke your bond and you will be stuck in there for at least 6, maybe 10, maybe 12 hours. And that's when immigration will put their clutches all over you. This is the only warning you're going to get. Heed this warning. How old are you, sir? What do you do for a living? How much money do you make a month?
Como unos 3,000 al mes.
All right, we're going to give you time to go hire a lawyer. So I'm going to have you come up here.
I have an attorney.
Oh, you do?
Sí, hay abogado.
Business.
Androgen.
Oh, and droga? Okay, so this is what we'll do. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria to sign a reset. I'll have you meet with Fleischer for your bond conditions, and then we'll just have you wait in back for your lawyer to arrive.
Gracias.
Please.
Thank you, sir.
And he had felony court today. And so I advised him to come down here after felony court, just maybe more expedient. Overall, he's here in the back.
Come up, Mr. Lara. Are you representing him upstairs?
No, not upstairs. But I guess have learned that they have a TRAS set on the felony charge upstairs. He is made bond here on our case. And I think we need to get some bond conditions put in place. I talked with the state, we're amenable to no contact, no going near the protected address that is the subject of the individual.
I'm going to put a monitor on you, though. You're a flight risk and you're on felony probation. You continue to do whatever you want to do when you want to do it. The court system doesn't work like that. And I'm going to tell you now, you ever take off on me again, I'm going to make your bond so high you'll have teeth falling out. Do you understand?
Yes, sir.
You will now get a leg monitor so we know where you are at all times. It's a GPS monitor. If you fail to charge it, I'm going to revoke your bond. All you're doing is enriching bonding companies every time you take off, because all we do is we revoke it, raise it, you're throwing money. So if you have a lot of free money, great. Do you understand?
Yes, sir.
You're not to have contact with the complaining witness. You're not to be in possession of any weapons. Do we know what is expected with the TRAS or no?
I don't at this moment.
No.
I think that just.
When is the TRAS set for? Do you know? Let me see.
February. And I think the felony date said February 19th, if I'm not mistaken.
So I'm not going to hold this case open for that long, right? So we need to figure out a resolution here. So what I'll do is I'll give you, 3 weeks. When you come back, you guys need to let me know what you want to do. But there's no way that I'm holding this case open for that felony case. No, you need to decide what you want to do here. And then when you come back next time, you must either accept the plea bargain or I'm going to set your case for trial. Do you understand? Okay. All right.
Okay.
Gotcha. See you in 3 weeks.
Judge, did you want the, contact address for the exclusion zone as well?
Correct. Assuming that's the same, right?
Yes, ma'am.
This is where frustration meets reality. The judge isn't angry about the items, he's reacting to the pattern. Repeated low-level theft can legally snowball into felony exposure, even if
What's
each
wrong with your
item
leg,
seems
Mr. Thomas?
minor. This is how people get trapped in the system. The court
That's why he
even
says the
offers
doctor 3 times
resources,
at this point,
housing,
and he
food,
can be able to
help,
go to jail.
but
You driving the
warns,
car in the
keep
accident?
reoffending and mercy disappears.
He was rear-ended.
I don't think he's supposed to be driving. You're not supposed to.
Valid.
You signed an affidavit promising me not to drive. Now you're driving. Now you get into a car accident. Did you have a breath test device in your car?
Yes. I had the portable.
No. Anytime you were to drive, you're supposed to have an interlock in your car. He is driving and he's not supposed to be driving and he doesn't even have an interlock in the car.
Device that the court had.
You're supposed to have an interlock in a car, Mr. Thomas. I'm taking you into custody today. The other thing that I'm going to do, Mr. Thomas, is that you will now be required to pay the $6,500 fee to DPS. And if you fail to pay it, every $100 you owe, you will sit in jail. $100. You're now going, how much are court costs in this case? From now on, you are not my problem anymore. This DWI is going to go on your record. This now makes 2. What happens on your next one? 2 to 10 in the penitentiary. Apparently, everything that we've done with you here was not enough to get your attention. I ordered you not to drive any vehicle that didn't have an interlock. I had you sign an affidavit promising me not to drive until you had court approval and you had an interlock in your car. And you drove, you are now in an accident. You are lucky that I'm going to even follow this deal. But as a part of this deal, I want you to understand you will now be required to pay all fines, fees, court costs associated with this case. And like I said, if you fail to pay even 1 iota, every $100 that you owe, you will sit 1 day in jail. You are now going to owe to the tune of around $7,000. And if you fail to pay it, every $100 is a day in jail. So you can now calculate how much you will sit in custody if you fail to pay this fee. Do you understand?
Yes, sir.
At some point, we now need to reach you to tell you what you're doing is not okay because you keep and continue to do and violate court orders. Like I said, I will issue the capias on this case if you fail to pay, number 1. Number 2, you're not my problem anymore because you will be facing prison time from now on. So I truly hope that you get the fact that if you ever have any kind of substance in your body, any smell of anything funky, and you get pulled over. Have you been to the penitentiary before?
So,
How many times have you been to the penitentiary? You now are a 15 to life case if you pick up another DWI, because they can use your prior pen trip to enhance you to a 15 to life if you ever pick up another DWI. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. I'm now going to sentence you to 30 days in jail. How much credit does he have? He has 1 day credit. 4 days credit, or look it up. 4 days?
Yes.
Okay, 4 days credit. You will be required to pay all fines and fees and court costs. I am suspending your license. I am suspending your license for 2 years. Do not drive. Do you understand? I don't care what is going on in your life. I don't care where you have to go. I don't care what you have to do. You get into a car and drive, you're going to be back here with me. And I'm going to tell you now, it's not going to go well. Do you understand?
yes, sir, I do.
And what are the fines and fees and costs of the year? You now owe $6,440 that you're going to pay. How do you plead to the offense of driving while intoxicated, a second offense? I will find you guilty. I will sentence you to it. Goes with you. Oh. Is it true that you had a prior DWI in here in 2021? Is it true that you had a prior aggravated assault of a family member?
Yes.
In 2023. I think it's only the first one because he's doing 30 days. So just do the first enhancement.
Okay.
All right. It goes with you. Thanks, Connor. Gotcha. Okay.
He tested positive, Your Honor.
I don't, I mean, one time in there wasn't enough? Apparently not. You're still testing positive for marijuana. Where do we go from here?
What happened?
It's just tough, man.
But it wasn't me. It was, can I tell you?
Secondhand smoking. Yeah.
Yeah, secondhand smoke.
Yeah,
I
he
think
was-
I believe that.
They don't want to hear it.
I
They don't want
understand. I
to.
understand this. I understand it.
So, just don't want it.
When was the last couple times, before the last 2 days, when was the last, guys, when was the last time Mr. Cabrera tested?
The last time I tested was July 30th, positive.
It never even stopped. We took him into custody when? When did we take Cabrera in? I reinstated his bond July 10th. I let you out of jail July 10th. and you promised me that you would stop smoking. July 10th. We are now in October and you still have a positive test.
Can I tell you something, sir?
Don't tell him that stuff about secondhand smoking. That ain't.
He's not gonna believe it. I understand that.
You try to tell me it's secondhand smoke. I don't believe it.
I understand that, sir. Understand it.
Why are you continuing to test positive?
Because you know how it's to go to school, right? And then all the restrooms are all full of hot box smoke. And I already went to talk to my teachers about that. If I could like go to a specific restroom by myself, but they can't let me. So all the restrooms being hot box, and I just be like, instead like if going to another restroom, I can't go anywhere because all the restrooms like upstairs, downstairs are full of smoke, and you can't do anything about it.
So every single restroom in your high school smells like pot smoke. So you can't go to the bathroom without now testing positive for marijuana. Really?
As a school, is it true that they have the problem with that school? San Marino is the most like ghetto school in Pasadena. That is just
you don't go to the bathroom.
It's right. All right, I won't go no more.
No, it's too late now.
I understand that.
Mr. Reyes, I don't understand. I mean, where do we go?
It's tough, Judge. It is. Well, when are you supposed to graduate?
Right, this year already. That's why I was planning. I'm still going to school.
October, when in December?
In May.
Oh, you still have.
Yeah, I still
until
got
next year.
Yeah.
Okay. All right. We're trying to get him into PTI, Your Honor. I'm sure it's going to take about 30 days to do all the paperwork for PTI. He blew a 10.
He can't even stay positive
That's
while
what
he's
I'm-
on bond. How in the hell is he going to make a probation?
Yeah, I guess.
I'll show you the.
Your promises mean nothing.
I understand. That would just be quite sorry.
We can bring him back in 30 days and test him again, Your Honor.
When is the last time you smoked weed?
Just tell him the truth.
The last time, I'm not gonna lie, it was a month ago, like a month ago. I'm not lying. That was the last time. That's what I'm telling you. You give me 2 more weeks, I'll promise I'll be clean because it's literally getting out of my system. I'm not lying, sir. I'll give you my word on my mom. I have a baby in the way. That's what I'm trying to push forward.
Bet.
Yes, sir.
Got
I'll
2 weeks,
give you-
Mr.
I'll
Cabadetta.
give you
You're
my
going to
word.
come here in exactly 14 days.
Yes, sir.
Take another test. If you test.
You think you can
again?
I'll put this negative, sir. I'll give you my word because I have a baby on my way. You guys, my mom.
November 5th, you
Yes,
will
sir.
come right back here. You will take another test on November 5th.
Got it, sir.
And if you test positive again,
You think he's going to test? It's still going to be in his system in 2 weeks.
Oh, mom. Oh, can I tell you something?
he told me just now, I asked him to be,
Even a month ago, so it's gonna get out because it's getting
Okay,
out of my
all
system.
right, okay.
Because
2
the guy
weeks will
showed me
be
the thing.
45 days.
The negative line was starting to show, but he said that it was still positive for him, so that's fine.
Okay,
Yes, sir. I'll give you my word.
we'll do.
see what your word is. If you test negative, I will send you on your way. If you test positive, we'll see.
I appreciate
2 weeks it is.
Thanks, Judge.
Hey, George.
Thanks a lot.
Credit is here.
So that's doing 3 days.
Good morning, Mr. Abraham. Mr. Abraham, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 9 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. You will be facing a minimum of 90 days in jail for any new cases that you pick up. You also need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point that will hit you with a felony offense, and then you're looking at years instead of days. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this or undo this. Is this what you want to do?
Sir.
How do you plead to the offense, guilty or not guilty? How do you plead to the offense of theft? Guilty or not guilty?
Guilty, but I didn't say that much, $2,000 worth for anything.
No. What is a theft? You're charged with theft. I'll be giving you the range of punishment.
Oh, okay.
Okay, so you've worked out a deal, 3 days in jail, credit for the 9 days. What is it? Is it a Walmart? Their problem also compounding this is you will not be getting out today because you have picked up an unauthorized use of a motor vehicle. Your bond is set at $10,000. So until you make that bond, you're kind of stuck in there.
I'm seeing Timberwood Shopping Center. I know there's a specs there, but I think it's like a shopping mall, so.
That's where the theft is from.
It is a dollar store right there. Yes,
Okay.
sir.
Is it true or untrue?
Yes, sir.
Okay. We wish you the best of luck. All right.
Right, thank you.
Okay. Stephen. Thanks. All right. Sure. Good morning, Mr. Brooker.
Good morning, how are you? It's a criminal trespass charge.
Okay.
3 days and 2 days dependent.
Mr. Williams. So you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You guys, I guess, have worked out an agreement. They're offering you time served. This is what you want to do.
Yes, sir.
You need to understand that it's going to go on your record from now on. You're facing a minimum of 30 days in jail for any new cases that you pick up. You also give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir? You high right now?
I don't believe he's intoxicated, Judge, at all.
How do you plead to the offense, sir?
Trespass. Guilty.
Guilty, I'll find you guilty, send you to the agreement. I'll roll your court costs so you won't know anything.
Thank you, Judge.
Except for Mr. Williams.
Yes, sir.
You know, you got the one.
This is the courtroom redline moment. Bond conditions aren't suggestions, they're court orders. The judge isn't punishing past behavior here, he's warning about future consequences. Once a judge says no contact, intent doesn't matter anymore, only compliance does.
Don't agree that that's right. We also agree that he's being held accountable for things that aren't really applicable in this case. You know, and
I'm asking him not to use drugs or alcohol.
I know.
That's all I'm asking him to do. And he's constantly testing positive, and now he's taking a Whizzinator into the room.
Well, it's wrong. And we don't want.
He can be charged criminally for that. That's an offense in and of itself. Falsifying a drug test, it's a Class B misdemeanor. You're facing another 6 months in jail and or a $2,000 fine.
What about, I mean, our concern and his concern is simple. This girl.
I'm not, no, we're not talking about the case. We're talking.
What is the case?
No, we're talking about the ability to remain clean and sober, first and foremost. We're not even talking about the case at this point. We're only talking about remaining clean and sober. He's repeatedly been unable to do that. And now he's trying to fool us.
Well, he has an issue that we know.
May I
You
say
know.
something on?
Okay. I think what needs to happen is I think the first thing you need to do is you need to talk to your lawyer before you make any statements.
Yes, sir.
The only thing I'm going to say is that I'm extremely upset, disappointed, and taking you into custody. You know, you've repeatedly failed to appear for court. You've repeatedly tested positive for a lot of substances, and now you're trying to fool us yet again. It's unacceptable, and there has to be accountability, and you need to accept that you can't continue to do what you're doing. Mr. Terrell, you're digging yourself into a hole that you cannot crawl out of. This monkey on your back will be there for the rest of your life, and if you don't get out of it now, you're going to be 70 years old with the continual on your back, in and out of custody. You're so messed up right now, you can barely open your eyes, man.
Your Honor.
And I don't know if you're enabling it or you're closing your eyes because of the love that you have as a father, but
He has severe ADHD and severe Tourette's syndrome. And we put him in a recovery center and we told them, we sent him the documentation. They told us every day they were getting the medication they ever did. Never did, until they finally refused to answer my phone calls because I kept calling him up what he needs to be on. I said, this ADHD medicine robs him of his chemicals and his dopamine chemicals in his brain. And he goes, he uses drugs to put them back. And I said, the Tourette's makes him not make good decisions. It's not a good combination. And they said, yes, that's the case in almost many drug addicts with ADHD. And they wouldn't fix it, right? And so I got pretty upset with him because he got out and he had a pill bottle that he got the day he got out. They had never given him any pills the entire time he was there for these things. So I agree that it's a bad problem and a wrong problem, but I also agree it's not entirely his fault because he's got a chemical imbalance that nobody is addressing. And never has. He's had this since he was a young child. They've addressed his Tourette's, but they've never addressed the ADHD. And I didn't know until I spoke to a doctor a week ago, or a couple of weeks ago, before he went into the rehab. And the doctor said, they said, so he's got ADHD. And I said, yeah. And he says, does he have a problem with drugs? And I said, yeah. And he goes, why isn't he on Ritalin? And I go, what do you mean? He says, that's what Ritalin is for. And if he was speaking apparently from personal experience, so we tried to get him on Ritalin. They wouldn't do that because it's a substance itself. And they said that he could be abusing that substance. So we tried to get him on a secondary substance that's non-abusive. We have fought for weeks, months, and we can't. We finally got him a prescription just as he's now out and back in trouble. So I only beg that we don't want him on drugs. Right, but we understand that maybe there's some underlying compassionate issues, right? And I mean, I'd like to beat this on the end, but that doesn't work.
And it pains me because I think that as a father and as a mother, due to love, a lot of times, and I don't know necessarily you, but people tend to kind of shut their eyes.
No.
And become naive to the fact that they're using, and I'm not talking about marijuana. I'm talking about cocaine. I'm talking about meth.
Be careless. He's got a license for marijuana.
So regardless.
Any heavy drugs, cocaine or anything that's going to cause him a lifelong problem, no. I want him off of that stuff. But he's been in rehab 3 or 4 times. That doesn't really work. So I don't know what does work.
You gotta want it. One of the main things is you gotta want it. But be that as it may, he's trying to fool us, and it's unacceptable. And there has to be accountability for it. I can't just let him go when you're using a Whizzinator to try to fool us. It's unacceptable, and there has to be accountability. And the problem is that I think that what we need to do now is have him evaluated by our clinicians to see how we go forward.
Okay.
So what I'd like to do is, while he's in custody now, I can have it done in a very expedited manner. I can have it done within, today's what, Tuesday? We can hopefully have a report back by Friday to see, at the latest Monday, to see how we go forward. Our clinicians can talk to him, and if he's honest, figure a way to go about doing this. And I'm going to tell you now, while I have him here, I can pay everything for you so you don't have to pay for a dime. If you're on the outside, though, I can't pay for it.
We can forward you doctor's records and things like that.
My only concern and the only thing I want now is our clinicians to be able to speak to him to see where we go forward. Mr. Terrell, I'm going to have you what's called TRAS to see, it's an evaluation to see where we go from here. If we get this TRAS back and it tells me that your little bunny's jumping in the woods and that there's no problems, then I know that you weren't honest, and I'm going to make you go do it right back again. And we're going to continue to do it until you're honest. But You can lie to me, but you can't lie to yourself. You can't be like this forever. At some point, you're going to be a habitual and you're looking at 25 to life.
I
But
forgot
thank you
what
for
it
your
is.
patience.
Thank you for your patience, but
You don't have to. And I'm really, truly sorry
he
that
did man up and come in. He wasn't going to. We had to fight with him and beg with him. He didn't.
to come in.
He didn't want
Of
to come.
course, no one wants to go to jail.
And, because he said, I said, he's not gonna put you in jail. He goes, yes, he will. And I said, no, he has a heart. He's not gonna put you in jail. He knows that you have a problem. The problem is the issue, I mean, stopping the thing that's causing this is the
Is
issue.
your last name Mr. Terrell?
Yes.
We've tried that. I gave him to you.
But he didn't, we tried it, but like I said, the underlying cause, which we've only just recently found, or
They've
found that
never
it may,
treated
they've
the
never
symptoms.
treated.
I understand.
And
I
so here
understand.
he's untreated and still being treated like it's a normal case, and it's not really.
I tried. I've given him back to you guys. I've asked him repeatedly to stay sober and not use, and he continues to do so. No matter how many times I give him to you, it's
That's being
going
caused by something.
to continue, and you have to realize it. And if you think that just him saying, okay, I'm going to stop, or the Ritalin is going to make it stop,
It has for many people.
it may have. And yes, it may have.
So how long are you putting him in for?
I don't know. For now, I would like to have him TRAS to see where they go. My feeling is that they're probably going to say that he needs inpatient rehab,
Which he's already been to.
not in the jail.
Yes, he has. You sentenced him to that last year. WIMAC.
We didn't put him in WIMAC. Did we do WIMAC with him?
But they never actually treated the symptoms
They
So we have other, if WIMAC didn't work, we have other facilities that we can go to. And we've got at least 3 to 4 different facilities, and we can continue to put them into each facility until it takes.
He has this felony case that this case is associated with this next week. Yeah. Of which
So
we're
will they
hoping,
release
we're hoping gets thrown out of court.
They have also facilities as well to help treat as well. We both do. And we both have facilities. They have more resources than we do because there are more serious cases up there. So they have quite a bit of more resources.
It does look like he went to WIMAC, but that's mainly to address like this criminal attitudes and thinking. Now,
It was for drugs because he was on probation for drugs. That's why he was.
No. What she's saying is that
the program that he went to was supposed to address like this thinking, attitudes and things. So now we're gonna assess him now that we know that he has mental health issues and as well as substance use problems. So,
His went last time because of substance abuse. That was what it was for.
no, but she's saying no.
she said no, but this time.
Okay.
Well, I think, Judge, they might be referring to the deferred was adjudicated based off of drug violations. He tested positive for many times for drugs. That's why his guilt was adjudicated in that case in this court. I think that may be what they're referring to.
Yeah, it was because he was on probation for drugs. And they actually, put him in there. And then, when he came, he couldn't even get his lawyer when he came to court. He got a court-appointed lawyer when he had a lawyer who was paid for. And twice. And it was very frustrating to us that he doesn't seem to be getting fair treatment. It seems like he's being held as an example and be given as an example and not being given fair treatment. And
How is he not being given fair treatment?
well,
Tell me.
I just really wanted, my wife is not going to be happy if I.
Well, no, but it seems like you're blaming me for the situation,
No, sir. What we're trying to say that he never got an assessment for the mental issue.
And they were told over and over again. I wrote
They.
the court officials, the probation officers, everyone was told that he had these issues and problems. They did nothing about it. Okay, his attorney brought paperwork to the court, Mike Monk.
Yeah, since we gave him the paperwork with all the.
Nobody did
tests
anything
and
about
stuff,
it.
right?
So we keep
So-
going, you guys keep blaming this stuff, but you just keep holding him up as an example and punishing him, and then we never try to find out what's the problem.
Put people in jail when they violate conditions, when they do something against the law. We don't willy-nilly put people in jail for S and giggles. We don't do that here.
So why is
If
there?
someone has a true problem, then we give them the opportunity to try to do things on their own. When it becomes evident that they're unable to, that's when we try to step in. I don't do this out of hate.
Outside of, he, we know that he has a problem, but outside of that, like he has a felony charge, they aren't giving these bond requirements. And this misdemeanor court is giving these bond requirements, when the felony court is not. So.
Can't tell you what the felony court, I want to make sure that he's not using alcohol or drugs.
It has nothing to do with this case.
How do you know that?
Judge, there are facts in this case that do indicate that there were crack pipes recovered from the defendant. And that's most likely why.
How do you know that he's charged with a felony assault? He's charged with interference with emergency request for assistance. How do you know that the drugs and alcohol that are using did not impact this?
Because he was sound asleep. All right, and she stuck a machete through his TV.
Not the
Okay, I know, we're not supposed to talk about it. I apologize.
Look,
It just feels very wrong.
I know that you see through the eyes of a loving father, and I'm not going to fault you for that. I get it, and I understand that, and I'm sorry. I really am. But I think that the best thing for him now is in a facility that he doesn't have access to drugs or alcohol. And I'm trying to do my best to keep him clean and sober. He tried to fool us now by using a Whizzinator.
This is why he didn't want to come in here. He would rather be run, that's why he didn't want to come back.
Okay, and you can't run forever, Mr. Terrell.
I know, I tell. But
So it's better to man up and get it done now than to run forever and do some irreparable damage by taking something that you kill yourself, right? Because that's invariably what's going to happen. The dope that you're using, you're going to kill yourself. He can barely open his eyes, man. This boy,
I'm listening to everything you're saying, sir.
You're so high right now, you can barely open your eyes.
I'm not high at all, actually. I'm sober. So, I mean, you can. At this point, I'm already in handcuffs, so it really doesn't fucking matter what I say.
No, he's not. I know, we've been with him for 2 days.
And I'm going to ask you, just bear with me. I'm trying to do the best I can to keep him clean and sober so he doesn't pick up new cases.
You haven't revoked his bond, is what he's asking.
Yes, I'm revoking his bond. I'm setting it at 20,004 right now. But if you bond him out, that's your choice. But I'm going to continue with the same things that I'm doing. And I'm now going to have him come twice a week to test with me. And the next time he tests positive, and I don't care what it is, the bond is going to end up even higher than it is. And at some point, we're going to address the issue. But I'm not going to continue to let you use drugs while you're out there in the free world. That's it. Huh? Yeah. Well, the first thing we have to do is we have to evaluate to see which one is the best one. They have mental health caseloads. They have the first thing that needs to happen is we have to have him evaluate, speak to a clinician. They can tell us which the best path to go forward. They may say he needs intensive outpatient treatment. They may say he needs SADF, which is an inpatient facility. I don't know until we have him evaluated. But understand, I like your son. I want the best for him. I really, truly, and he doesn't get it.
No, because we watch on TikTok him being in front of your court, and we're going, what the heck is that doing on TikTok,
I live stream all our proceedings, and that's what we do. So adds transparency. So
I'm going to have to excuse myself. I'm not helping, I know.
Look, you're not making us mad, and I understand how you feel, and I get the loving father. I would be in the same position as you, but I want to keep him clean and sober. That's the bottom line. I've tried to do it the other way. It's not happening and he's fooling us. So the only recourse I have is this. So if we can set it to your ASAP, hopefully we can have the report back by Friday, at the latest Monday. They will tell us which is the correct course to go. And then we can all sit and talk and decide what to do. You know, at the end of the day, if you want me to just do nothing and
I'd rather you help him.
you know, if you want me to let him go and just
Yeah.
fend for himself, then it's on you. But know this is that what you guys are doing now, it's not working. He's slowly killing himself, as evidenced by his demeanor, the way he looks. He's killing himself slowly. And before long, he's going to really deteriorate I've seen it happen all too much. All right.
And Judge, before we end this conversation with this defendant, I've spoken at pretrial about the records that they have about the defendant and what he did today. I'd like to obtain those records and get those provided to defense counsel as well and provide that to felony. They're willing to provide that to me upon your oral consent to that. Okay? Pretrial, do you hear that? Okay, great. Thank you, Judge.
So get him in more trouble.
No one's in more trouble. I mean, do you not see what I'm trying to do? If we wanted to put him in more trouble, we charge him with additional offenses.
Isn't that what he's trying to do?
No, we're not here to punish and enslave and to kill. We're here to help. And sometimes that may require this. Out there, it's not working.
Do I have your word that it's not going to come back?
No, I don't make the charging decisions. I'm not going to give you any kind of word. I'm going to give you my word that I'm going to try to help him as much as I can. But I need your help with that as well. I need your help with that as well. Look, I don't want to have any discussions until with the case, with anything as well. Hold on a second. Hold on. Wait a second. Hold on. Just about giving the records to Mr. Haddad. Hold on a second. Until he talks to his lawyer, we shouldn't talk about the case at all. My only concern now is being clean and sober. That's my only concern at this point. Okay? So we're going to take him back. We'll have him TRAS as soon as possible. We can set it for Friday. Hopefully we can have the records back by then as far as what the thing is. And we'll go from there. Okay?
And Judge?
Yasha.
Yes, when can I come back to follow up on this matter? Can I come back tomorrow?
When can we have him TRAS?
Monday, because he has to be processed today. So,
Wait.
I can see if somebody can come in the holdover.
What day you say?
I'm just trying to keep this stuff out of evidence.
So let's say we take him in now, he gets processed today, he's in POP tomorrow.
Not talking from.
If it doesn't get brought back to court tomorrow, then yes, it should stay there. Let's do Tuesday, just to be safe and have the report.
Next Tuesday.
If it's back sooner.
Oh, you mean for the report to be back? Oh, okay. But I'm talking the actual evaluation. When do you think? Maybe Wednesday? Friday.
Because it has to be processed. I don't know how long it's gonna take.
Private issue.
Okay, all right. Okay. I'm gonna try to have him evaluated as quick as possible. Hopefully we can have it done by Friday and the report back by Monday or Tuesday, okay? I'm gonna put him back now. So Yasha, if you'd like, we'll have you call the holdover so you can talk to Mr. Terrell now. Is there anything else you wanted to add?
Judge, I confirm whatever Mr. Terrell just said, about the fact that he needs help. He needs to use his medication. I believe that if he does start using the medication, it will help his situation. I don't think jail time or incarceration is the solution. I really think that he needs help with his medication and some sort of rehab to get out of the situation he is in right now. I am actively working on both cases, the misdemeanor and the felony. I have provided some evidence to the felony prosecutors. about the situation. And I'll keep checking back with them. If I have to go every day, I will.
Okay, and I trust that you will, Yasha, but unfortunately, due to him bringing a Whizzinator into the drug testing room to try to, fool us, it's unacceptable. And I'm going to revoke his bond because of it. We're going to keep him. We'll try to have him, TRAS as quick as possible to see how we go forward.
Yes, and let's get him TRAS, and then I will look at the report and I will discuss it with him and his family, okay?
Look, at a minimum, the TRAS will tell us which way they believe is the best course of action. I will leave it to you guys to decide whether you want to do it or not. If you don't want to do it, if you just want to, let him out and fend for himself, it's up to you guys. I will offer my services to you for free. If you want it, it's available to you. If you don't want it, then it's on you guys. Okay?
You need to take pills.
Let's not talk about everything now. Let's just
See for me? Judge, did you say?
Well, hold on. Yeah.
Yes, sir.
I want to know what
Yes, Judge.
do you want everything? Is
Yes,
it, why do you want all that?
So, Judge, that's.
To further charge?
I'm not going to personally charge Judge, but I think that the state has a right to know about this if he's violating bond conditions for our purposes. I don't know what it's going to be used for yet, but I think that the state and defense have a right to have this information, Judge.
No, I'm not, no. I know, because I don't want to add further fuel to the fire and damage. I don't think it's fair. How is that,
Judge? He's violating your conditions
and he's going in there now.
I understand, but you don't think that the state has a right to this information?
I don't know. Let me look into it. I'll get back to you on it.
Yes, Judge. I'll get back to you. Respect the court. I defer to your judgment.
I understand.
I believe that.
Let me talk about it and then I'll get back to you tomorrow.
Okay.
And we'll talk about it.
You file a written motion.
Sure.
Okay.
Yeah.
Okay. Yes, Judge. Yes, Judge.
Okay.
Judge, do you want me to stop by tomorrow?
Yes, stop by and we'll talk about it as well. Okay.
Okay. And I will contact Mr. Terrell.
This is where things quietly turn serious. When someone is lawfully asked to leave private property and refuses, that alone can establish criminal trespass in Texas. Even more important, notice how compliance with arrest does not erase the charge.
Yep. Come up, Mr.
Many
Osborne.
viewers think he cooperated, so he should be fine.
Guys,
But cooperation affects arrest,
all the times
not
that we've had
probable
Mr.
cause.
Osborne tested, times that he's been positive, times that he's been negative. How many times have we tested Mr. Osborne, please? It's nearly 400 days old and he's continuing to smoke weed.
This is the first time he's actually been tested, to my knowledge.
I don't think that's right. I think that we've tested him before.
I understand he tested positive, Judge. My only concern is he is trying to get a degree, and obviously through his own doing, he's missed a lot of days of school, but I'm concerned that he's not.
Since December 21st of 23, he has had a dismissal offer where he's had to do 12 hours of community service, one class, and he gets his case dismissed. Now, a year later, we are still here and he's testing positive for marijuana.
Only number I had for him was his mother's number, which is why he got disconnected. I could not figure out how to contact him, which is why I had the PTI offer, but I couldn't reach him to give him the
It's
PTI.
not your fault, Mr. Schofield, and I'm not going to let you fall on the sword for him. But you're still smoking.
Only one judge,
Just the one today?
Yes.
We've never tested him before?
and we have a record now.
Where are we going?
He signed the PTI yesterday, so he's just got to get his community service and his anger management done.
What kind of anger management class are we talking?
Our anger management class, and he has 12 hours of community service.
You have 3 weeks to get everything done. If you don't have everything done in 3 weeks, you will get an immediate trial setting. This offer goes away. Do you understand, Mr. Osborne?
Yes, sir.
And the next time you test positive, I'm going to light you up. No more weed. How old are you?
18.
No more weed. Do you understand?
Sir.
You will get tested again. And if I find that you're continuing to smoke weed, into jail you will go. You have 3 weeks to get this thing done. That's it.
Thank you, Your Honor.
Hey. Hey.
Yeah. That's 3-1, Judge.
What's the last name?
Tomas Gonzalez.
What page is it on? Did on talk it today?
Page 14.
Yes.
Marcelino, okay. Mr. Marcelino Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that by pleading guilty to this offense, it will go on your record. It's going to be there for the rest of your natural born life. If you ever get pulled over in a car and you have an alcohol on your breath and the officer sees that you have a prior DWI, what do you think they're going to do to you? Right.
Yes.
What we're doing today, you will now be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? And if you are not in this country with permission, you go to jail for that time. I can all but guarantee that you will get an immigration detainer. So if you have people that depend on you for whatever purpose, you going to jail for that kind of time completely wastes them. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record. It will be there until the day you die. Do you understand?
Yes.
Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to the 3 days in jail, give you credit for the 1. I'm going to suspend your license for 90 days. Do not drive until you get a license. Otherwise, you will be right back over here. Are you appointed on the case?
Yes, sir.
Okay. You run it, Cece. Good luck to you, Mr. Marcelino.
What is the big difference?
3,000. Oh, it's 3,500.